Alright, so Florida just made a major move that's got legal circles and political observers buzzing. On April 8, 2025, Florida's Attorney General James Uthmeier dropped a policy memo that bans law firms with diversity, equity, and inclusion programs, DEI for short, from serving as outside legal counsel for the state. Yeah, you heard that right. If your law firm supports DEI initiatives, the Florida AG's office doesn't want to work with you. Now, before we dive deeper, let's talk about what this actually means. Uthmeier says that DEI, along with ESG, environmental, social, and governance, violates the principle of equal justice under the law. In his view, taxpayer money shouldn't be used to support what he sees as discriminatory practices. So how strict is this policy? Pretty strict. It covers a wide range of DEI-related practices. If a law firm has something like the Mansfield certification, which promotes diversity in leadership, or if they use racial diversity scorecards, have hiring targets based on race, or offer racially exclusive fellowships, they're out. Even things like DEI mentorship programs, dedicated hiring websites, or company-wide DEI training sessions can disqualify them. And it doesn't stop there. Firms connected to third-party diversity groups like the Leadership Council on Legal Diversity, or those that follow ESG frameworks, are also under scrutiny. But here's an interesting twist. Individual lawyers from those firms might still be considered if they personally reject DEI and ESG principles. So it's not a total blacklist, but it's definitely a hard line. This move isn't exactly out of nowhere. It fits right into a broader effort led by Governor Ron DeSantis to push back against DEI programs across Florida. You might remember the Stop Woke Act from 2022. Parts of it were blocked in court, but it aimed to limit how race and identity could be discussed in schools and workplaces. Then in 2023, Florida passed a law banning public colleges from spending state or federal funds on DEI initiatives. And just last month, the state's Supreme Court considered a proposal to drop the requirement for law students to graduate from ABA-accredited schools. Why? Because the American Bar Association has diversity mandates that Florida officials don't support. So yeah, this is part of a larger trend, one that's reshaping how DEI is treated in government policy, education, and now legal partnerships. Now, depending on where you stand, this is either a bold defense of equality under the law or a politically charged attack on programs meant to promote inclusion. Supporters say DEI programs unfairly prioritize identity over merit. Critics argue that banning them only ignores the inequalities they were designed to address. But no matter how you feel about it, Florida's decision is a big deal, and it could have ripple effects across the country. Law firms doing business with government agencies might start rethinking their internal policies. Other states could follow Florida's lead or push back in the opposite direction. And for lawyers, students, and institutions watching this unfold, it raises a big question. How do you balance inclusion with neutrality in the eyes of the law? This story is still developing, and I'll be keeping an eye on how it plays out. If you found this breakdown helpful, hit that like button and subscribe for more bite-sized explainers on the issues shaping your world. Thanks for watching.